Hello friends, welcome to Simzuu again. Friends, you are already aware we are discussing labor codes. We have started a new series and this is part 2 of industrial relations code, and I am discussing 10 major changes. I believe 2 or 3 we have already discussed it in part A, and the remainder I am going to discuss it right now. Now friends, you are already aware that the transition because of the labor codes is a fundamental shift, and it is a shift from statute based regulation to a thematic unified framework. And what it further caters to, why consolidate the all the labor laws into 4 labor codes? Because they collectively aim at something. And what is that collective aim? We have to understand that first, and then I will again continue, is to reduce the legal complexity. Everywhere it should not be a maze, it should be an easy flow. This is the definition, this is what I understand. Remove overlaps and contradictions. Well, this is some definition, I read it in that act. What is it? So at the same time you refer to 3 acts. No, it should be a smooth flow. One definition, which would be a uniform definition. Then what about digital governance? Yes, we have to have digital governance. How many years are we going to travel by bullock carts? Then there are cars, so are we not going to travel by cars? Same with technology. How many years are we going to have inspectors visiting? Can't there be some software driven technology? That is what we are going to see, and that is what the labor codes provide. Then to extend protection to the modern workforce. See, India became independent in 1947, and the workman in 1947 is not the workman in 2026. They have changed. So what are his needs? What does it cater to? How should we change? How should government change? How should government change the law? What new definition should be there? What new employment should be there? Everything is taken care of, which of course we are going to discuss. And then balance worker welfare with business flexibility. Normally, see, our minds are conditioned that even journalists or anybody who they ask questions, what do you think? These labor codes are worker friendly or management friendly? Why can't they be both? They are friendly for the management, flexible for the management, as well as cater to the welfare of the workers also. And how? That's what exactly I am going to comment upon and then show you. But friends, we proceed with, I am to explain you as to what are the 10 major changes brought about by the Industrial Relations Code, of which 3 we have already seen in part 1. Those who have not seen part 1, kindly see that, and this is part 2. So we continue, friends. So friends, we were discussing in the last video fixed term employees. Fixed term employees is a new concept, which of course is absent in the model standing orders applicable in state of Maharashtra. In other states, it could be something a bit different, but ultimately the fundamentals of law remain the same. Then you see gratuity for fixed term employees, which is pro rata per year. If at all he is working, he has to be paid. Just to give you an example, say I am the worker. I work in A company for 4 years, B for 4 years, C for 4 years, and D for 4 years. My total employment is 16 years, but how much gratuity do I get? Under the Payment of Gratuity Act 1972 is a big zero. This would be the change. So here, managements also will say, I require only 50 workers or 100 workers for a span of 2 years or 3 years. So I am allowed to employ them. Only thing is that I have to pay them gratuity pro rata, that is per year. Of course, some are under a mistaken belief that FT is FT and then everybody gets gratuity. No, gratuity after 5 years is not ruled out. That employment is there. This pro rata gratuity is only for fixed term employees. Okay. Then friends, what we see is this negotiating union. What is a negotiating union? Today you see, especially in state of Maharashtra, we have the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labour Practices Act 1971. So recognition here is granted by the Honorable Industrial Court. And what is the concept of recognition of a union? It is an inter-union dispute. There are two unions. They fight for a recognition depending on their membership. So they file up applications under the MRTO and Pulp Act 1971 before the Honorable Industrial Court. After everything is verified by the registrar, whichever union has the majority gets the recognition. Now this is done away with in the labor codes. Here it will be the employer who will be granting the recognition to a union which is having more than 51% of the membership. So in a company or in any industry, you have 51% of the membership. So the employer will grant recognition to that union. Now friends, it can also be possible this way, that there could be many unions and no union enjoys more than 51% of the membership. So this is 20% here, 20% here, 20% of that union. So ultimately, whom should the management discuss with? Here in this case, the labor codes say that there could be a negotiating council. So a negotiating council will be made which will have representation of each and every union. Women representation is encouraged, and ultimately there will be a council. So this is a negotiating council. So you negotiate with the council. Then friends, one of the mandatory changes which have been made is expansion of the worker definition. As you understand, under the Industrial Disputes Act, a workman is defined under section 2S of the Industrial Disputes Act, that whoever does manual, skilled, unskilled, technical, clerical and operational work and supervisory, he is a workman. We have already made videos on that, you can see them. Now the ceiling, wage ceiling under the present act is 10,000 rupees per mensum. That is, he is a workman who earns less than 10,000 rupees per mensum, that is per month. Now this limit has been increased to 18,000 rupees, which covers more supervisory and technical staff. So it is a wider protective net which has been given. So the threshold of 10,000 is increased to 18,000 is also one of the major changes. Then friends, next major change is a mandatory notice of strikes and lockouts. 14 days prior notice is mandatory, and notice remains valid for a period of 60 days, and it applies to all establishments and not just to public utility services. And this is an attempt to curtail sudden strikes. Under the types of strikes, in earlier of our videos we have seen there is a general strike, there is an en masse casual leave. Moreover, en masse casual leave is now treated as a perfect strike. So you cannot hold the industry to ransom. I mean, some unscrupulous unions, as there are unscrupulous managements, there could be unscrupulous unions also, and they hold the total system to ransom. The leader will come and in a flash of a second he will declare a quickie or a lightning strike and chalo kaam band kar do, and everybody drops their tools. This is done away with. You must give a notice now. Notice is mandatory so that the employer, either he can rush to the court, get some interim relief, or make an alternative arrangement, or whatever is the thing which could follow. Now as you understand that for say strike is the last weapon in the armory of labor, and an antithesis to the strike or the last weapon in the armory of the management to answer a strike is a lockout. And all these provisions, as these new provisions I am saying, 14 days notice, as they apply to strikes, they also apply to lockouts also. Then friends, there is a time bound resolution. Conciliation proceedings are to be within a span of 45 days. There are umpteen number of judgments wherein, I mean, some people entertained conciliation after 3 years and complaints after 4 years, and then it went on and on and on. Is there going to be a limit on that? Because ultimately it increases the burden on courts also, and then we all in an equivocal chorus, we keep shouting what is happening in court. So many of the cases are in cold storage, but it is to be nipped in the bud. So what we see is conciliation proceedings will be for 45 days, and thereafter the worker can take up the matter and rake it up before the industrial tribunal. Industrial tribunal is to dispose the matter within a period of 1 year, and this is to be aimed at speedier and faster justice. Moreover, you will find that there is a grievance committee also introduced. Grievance committee will first decide whether there is a real dispute or not, and if at all people are dissatisfied with that, then they can take it up before the conciliation officer. Is a major change. Then friends, the next major change is reskilling fund for retrenched workers. Now you see, workers are retrenched. What is retrenchment? Ultimately it amounts to termination. Retrenchment, as you understand, is defined in section 200 of the Industrial Disputes Act. Year numbers could be a bit different, but then what we see is that in retrenchment, I pay him 15 days of average pay per completed year of service, 1 month's notice pay, current wages, say today is what day, so till today I calculate that wages are paid, that makes up a retrenchment compensation. Then I issue letters to the Labour Commissioner, to Mantralay, to the Secretary in Mantralay. Procedural formalities are completed, reasons of the retrenchment are there, calculations are made, everything is done away with, and then I retrench. What happens to the worker? Does he get a job the another day? No. So what they have done in the labor codes is, if I have retrenched somebody, I have to yet give 15 days of average pay and deposit it, that is the pay, with the appropriate government. And the appropriate government will then go on developing a big corpus which will be called as a reskilling fund. And this reskilling fund is what? It's for reskilling of the workmen who are retrenched. So some sort of a different skill he learns. And today, he wants to learn, government wants to teach, but there is no fund. So this is a way in which funding is also raised, and then we see the reskilling fund will go on mounting, and there will be a snowballing effect. So today we have this much of this reskilling fund, but with every retrenchment, with every person adding to it, one day it will be a huge corpus wherein government can think of different schemes also, so that reskilling is really done in letter and spirit. And then friends, what we see is simplification and merger of 3 labor laws. So ultimately what we find is that the Industrial Relations Code subsumes Industrial Disputes Act 1947, Industrial Employment Standing Orders Act 1946, and the third one is the Trade Unions Act 1926. So these are the major changes. Of course, let me tell you, this is not the whole video which we have on labor codes. In fact, we have started the series. So we will be taking all of these things in detail. Possibly there could be one video on each of the changes which I mentioned and much more. And one more thing, friends, the concept of permanency with FTEs, I just mentioned FTE, that is fixed term employment. Today the mad rush is after becoming permanent. Now the flexibility point comes here. With fixed term employment, you get employment also, guaranteed employment also for a duration of time, and as far as the employer is concerned, he does not have to harbor under the bogey or the ghost that these people will claim permanency tomorrow. So no permanency could be claimed. So this is something we spoke of 10 major changes in the Industrial Relations Code. Again I repeat friends, those of you all who have not seen part 1, kindly see that. Then this is a sequel. Then you see part 2 so that you understand everything in one go. Okay. So it's time for me to bid a goodbye. We soon meet. Let me tell you that the 2 codes will be taken up by Shubhankar Malegaonkar, who is also a director at Malegaonkar and Associates. And there will be one more code wherein I am going to talk upon Again we are going to see what are the 10 major changes. Thank you friends.